This is the buyer-broker exclusive employment agreement, as written by the Arizona Association of Realtors. What this document is, it's a service contract between the brokerage and the buyer. And the buyer is asserting that the brokerage will be paid either a percentage of the sales price of the home they purchase or a set fee. Contract starts like most contracts do, with the buyer and the firm being spoken out. So line 1 and line 2, buyer is going to fill in their name and the firm's going to fill in their name and the agent that they're going to be working for. Like all contracts, it's going to have a term, and that it's going to commence on a certain date and expire on another certain date. The broker is agreeing to locate a certain property meeting the following general description. This can either be a residential, land purchase, commercial, or a lease. It's also going to negotiate, the broker is also going to negotiate the acceptable terms and conditions for the purchase, exchange option, or lease of this property for the buyer. And they're going to assist the buyer during the transaction with the scope of the broker's expertise and licensing. So if in the expertise in licensing is a broker cannot step outside of their expertise or act outside of their license. So a residential agent cannot help a buyer purchase a commercial property because it falls outside of their scope and training. They can work with another commercial real estate agent, usually in a apprenticeship role, where the commercial person will guide and advise and basically be the primary agent on that, while the other agent learns the ropes of how to do that. But brokerages, and particularly agents, are very, very carefully told, do not step outside of your area of expertise. Case in point, I'm a Phoenix agent. I work Maricopa County. I've been down, I've worked in parts of northern Pima, like Maricopa City itself, but I would never ever work with a buyer or even with a seller, let's say in Flagstaff or Yuma, areas that are outside of what I'm used to. So on an agency relationship is your next line. It's going to delineate that the agency relationship between the buyer and broker is going to be either set forth in the real estate agency disclosure and election form. We'll have another video on that, or in another way as described. So at this point, we are saying that the brokerage, and through the broker or sales agent, is going to help locate a property for the buyer and help negotiate a transaction for them. In return, the buyer is going to make sure that basically that the agent gets paid. There's various ways of doing this, right? The first one can be a retainer fee, all right? And the retainer fee is where the buyer's agreeing to broker that there's a non-refundable fee in the amount of X, all right, which is earned when paid for initial consultation and research. So this is an upfront retainer fee. The fee can or cannot be applied to or credited against any other compensation coming out in the middle of this. Line 16 through 19 is property viewings, and it calls out to make sure that the buyer understands that a buyer is agreeing to work exclusively with this broker and with this brokerage, and he's going to be accompanied by that broker and brokerage on buyer's first visit to any property. If the broker does not accompany the buyer on these visits, including model homes, new homes lots, or open houses held by a builder, seller, or other real estate broker, the buyer acknowledges that the builder, seller, or seller's broker may refuse to compensate the broker or the agent up front, which will eliminate any credit against compensation owed by buyer to broker. The agent is also the buyer is going to do their due diligence during the purchase. We covered this in the contract. This is more commonly known as the inspection period. All right? And they're going to act in good faith to acquire the property and conduct any inspections or investigation of the properties that buyer deems material and or important. In lines 22 through 25, we see the stigmatized property language we see in all other documents. We see this in the contract. We see this in the agency agreement. We see this in the SPUDs. Right? In Arizona, we have stigmatized property law. That means neither the seller or either agent needs to volunteer information if it has if the property has been the site of a natural death, all right, owner occupied by a person with AIDS or exposed to HIV, or located in the vicinity of a sex offender. Now, lines 26 through 27, right, is that the buyer is agreeing to consult the Arizona Department of Real Estate Buyers Advisory. There's a link there. Agents buyers working with me will get this in their orientation and introduction package. I hard print a copy out for them. All right. And this is going to help them, assist them in their inspections and investigations, and give them a general knowledge of what they're going to be going through when they purchase a house. All right. And then in lines 28 on is where we start talking about the compensation. All right. The buyer is agreeing to compensate the broker as follows. All right. The amount of compensation shall be fill in the blank. Each agent will have pick their own rate that they care to work at. Okay. And the compensation is going to be offset, all right, by the seller's contribution or the seller's payment to their broker and their broker making an agreement with other brokers to work with them. All right. So the buyer is authorizing the broker to accept that compensation from the seller and the seller's broker, and they also agreeing that their amount that they owe is going to be credited. The amount that the seller is paying is going to be credited against the buyer's debt on paying for their agent. So if you have a listing out there, a buyer broker agreement where the buyer has agreed to pay 3% of the purchase price to the buyer's agent, and the seller and seller's brokerage is offering 2.5%. Right? That 2.5% gets credited for the buyer's debt, and there's only a 0.5% remaining. Now, broker's compensation, all right, is going to be paid at the time of the closing, all right, and it's going to be considered a condition of closing as the other close of escrow condition that we see in the contract. Right. Now, the buyer is also going to agree that pay such compensation within a set period of calendar days after the termination of this agreement. Buyers into an agreement to purchase, exchange, option, or lease any property shown to the buyer or negotiated by the broker on behalf of the buyer during the terms of this agreement. So if we have a set time period of, let's say, 3 months, and after the 3 months, both agent and the buyer go their separate ways, and the buyer decides to go back to another property that the agent had shown them previously and negotiates a deal with the seller at that point, the buyer's agent has still earned their commission, and the buyer is agreeing to make sure that they're paid for that. Right? Now, lines 37 to 38 is in case the buyer has a breach of contract or fails to purchase the property without using having any other traditional ways to pull out of the contract because of inspections, appraisal contingency, or anything else. Right, and lines 39 and 40, we see this a lot. We see it in the contract. See within the listing agreements that the commissions payable are not set by any board or association of realtors or multiple listing service or any manner other than is negotiated by the broker and the buyer. On the next page, we have a list of additional terms, and additional terms on these things can be excluding a specific property. Buyers are out there looking for a property, and they know that they have a family member who may or may not be ready to sell a house, or they know that their family member's house may be coming up for sale while they're looking. They can actually come in here and exclude specific properties, say, except for mom and dad's place, or other terms, anything else you can come up with in, Arizona law. Speaking of Arizona law and federal law, lines 48 through 51. All right, this is equal housing opportunity. The broker is going to abide by all local, state, and federal laws prohibiting discrimination against any individual or group of individuals. All right, broker has no duty to disclose the racial, ethnic, or religious composition of any neighborhood, community, or building, nor whether persons with disabilities are housed in any home or facility, except that the broker may identify housing facilities meeting the needs of a disabled buyer. If you're working with a licensed sales agent in the state of Arizona, and particularly if you're dealing with a realtor, you cannot go to that individual and say, I don't want any of those people living around me. Don't put me in any neighborhood that has those people. That is a violation of the fair housing. Right? They will fire you on the spot, and you'll go out into the wilderness trying to find somebody who's going to represent you in that situation. But this is illegal in this country. Right? Now, lines 52 and 53, other potential buyers. Right? The buyer is consenting and acknowledging that the broker is and has the ability to work with other buyers at the same time. Sometimes these buyers might be looking for the same kind of property that you're looking for, and depending on how that individual agent and their broker feels like dealing with that situation, all right, ask them particularly about that. All right. Lines 54 through 61, alternative dispute resolution. All right. If there's a conflict, a dispute of this particular document right here, both signatories agreed that they're going to go through a mediation group, right, hosted by the local realtor association, and that the mediation on that will be binding. All right. If for some reason that does not resolve the issue and we go to court, attorney's fees and costs are going to be paid for by the loser. All right. Arizona law. This is an Arizona document. This is Arizona law in Arizona jurisdiction. All right. Copies and counterparts. If this document is signed by has two different copies, and both individuals sign their own separate copies, those two copies put together become the same copy. Another thing on this is that anything that is transmitted, emailed, faxed, or something like that is considered part of this. The entire agreement, this 2 pages here is the entire agreement. If anything is said verbally, it has to be written down and signed by both parties. And capacity is that the buyer is warranting that they have the capacity to enter into this legal document, and they also have the capacity to consummate and purchase property. All right. Then we have acceptance down at the bottom, and the last little bit of this, as you can see, is the management signatures on there, so it can be registered properly in our logs for review by the state authorities. And thank you very much. And